Good afternoon, and welcome to the overview of the Office of Workers' Compensation Program, Division of Federal Employees Compensation. My name is Jay Mariani. I'm the branch chief for fiscal operations, and I'm joined by Tara Jones, who's the branch chief for technical assistance. Just a few housekeeping items right away. We encourage lots of questions, please. It makes the whole thing go a lot smoother, easier for us to get to the things that you really want to hear about. So we encourage you to email to benefits@opm.gov frequently and often. We'll also take questions from the audience members should they have any as well. The FECA, the Federal Employees Compensation Act, dates all the way back to 1916. It makes us the oldest federal benefits program in the country. We predate Social Security by some 20, 25 years. We provide coverage for nearly 3 million federal employees in all aspects of workers' compensation, wage replacement, medical care, and where necessary, voc rehab assistance in returning to work. We also provide benefits to dependents in case of a federal employee being killed during the line of duty. As you know, we're from the Department of Labor, so we're part of OWCP. Our actual division is DFEC, the Division of Federal Employees Compensation. We adjudicate all new claims and all benefits, and we are the authority for all federal workers' compensation issues. So we'll give you some numbers just roughly so you can get sort of an idea of what we are. Like I said, 3 million people covered. We average about 120,000 new claims a year. Of those, we have, in fiscal year 2014, we had 13,000 claims with a notable disability period, more than 90 days. 88% of those were returned to work within that first year, and 91% returned to work by the end of the second year. So we do our best to get them all back as quickly as we can. Of course, to do that, we spend those hard-earned tax dollars. Nearly $3 billion a year in workers' compensation benefits are spent, $1.8 billion in comp, $951 million in medical benefits, and $113 million to survivor benefits. Now, that's not very much in OPM's world. You guys spend a lot more money than we do, but when it comes just down to workers' compensation, it's a fair amount of money. We're broken up into 12 district offices. We have a national office with 5 branches that handle all aspects of our business. My branch is the fiscal branch. Tara does technical assistance. We also have an IT branch. I'm blanking on the other 2. Regulations and policy and procedure, and hearings and review. Thank you very much. And as you can see, we're arranged geographically within our 12 district offices. So the various colors, depending on what state the claimant lives in, not necessarily works in, but where they live, is the office that will handle their claim. All individual cases are protected by the Privacy Act. Here's where we're a little bit different than a lot of other things that folks deal with. We are HIPAA exempt. It does not apply to us. Our system of records is completely unique from any other system of records. For benefit officers, that means you have to keep a completely separate system of records for your OWCP files. We can't be combined with all their other personnel records. Our records can't be used for anything else, such as grievances or personnel actions, or even to review for possible promotion or other job-seeking things. It has to be completely separate and apart, and they can only be used for the purpose of the workers' compensation claim. Now, that does mean it can be used to help return a person to work. When I say seeking a job, if you're trying to create a position for someone who's been injured and you're trying to come up with a brand new position for them, the contents of the OWCP case file can be used to get medical restrictions or to figure out what they are able to do, but only in the context of OWCP. It seems like a fine point, but we have a lot of problems when our records get used for other things. And you can imagine, because these are people's personal medical records, not their regular employment records. So it's very sensitive for us. And we have to be very careful that you keep a completely separate system of records.
So I'm going to cover types of claims. Just briefly, we'll get into the details of each category a little bit later, but the 3 types that we manage are basically traumatic injury claims, which are defined as having occurred over 1 day or work shift, occupational disease claims, which constitute an exposure happening over the course of more than 1 work day or work shift, and then death claims, as Jay mentioned earlier, which encompasses cases either resulting in a death at either the time of injury or later from conditions caused by the injury. So first I'm going to get into conditions of coverage. There are 5 basic elements that must be met in order for a claim to be accepted. Those are time, civilian, employee, fact of injury, performance of duty, and causal relationship. I won't spend too much time on the first 3 since they're pretty straightforward, but basically there is a timeliness factor that has to be met for claims filed, and that generally is that a claim must be filed within 3 years, either from the incident having occurred or from the employee becoming reasonably aware of it being connected in some way, of their condition being connected in some way to the work incident. A civilian employee, it's, again, pretty straightforward, exactly what it sounds like. The person must be a federal civilian employee. We generally do not cover contractors at all. There are certain instances in which volunteers may be covered, but again, generally it should be a federal civilian employee filing. Fact of injury, again, sounds exactly just what it is. Fact of injury deems that there must be some sort of condition arising from the actual incident or a diagnosis. And I'll spend a little bit more time talking about performance of duty and causal relationships, since those are a little bit more detailed and require more explanation. Okay, so as I mentioned, performance of duty, the fourth condition of coverage, basically states that the injury has to have occurred while the individual was performing assigned duties or engaging in an activity reasonably associated with the employment. So we'll talk about injuries occurring on the work premises. Again, they have to be performing their duties, but this can also include personal comfort activities reasonably incidental to employment. So, you know, if there's a lunch facility on the campus or on the work site and that person is injured at that point in time that they were having their lunch, there's a chance that that case could be covered.
Literally a broken tooth.
Yes.
If you're eating your lunch and your tooth breaks, the way our law is written, that would be covered under the Act.
The third sub-bullet there under work premises. So coverage can be extended for a reasonable time, either before or after work hours. So here we're talking about people entering and exiting the building before and after their work shift. We see cases where people might slip and fall during the wintertime if there's ice somewhere, you know, reasonably within the work premises area. So, but on a note on that, we do not cover travel to and from the work site at all, from home, generally. All right, so moving on, off-premises factors here. So this, you know, can encompass things like TDY, official travel, as long as the individual is performing their assigned duties, and, you know, again, engaged in an activity reasonably incidental to the assignment, including personal comfort. So, you know, just as we mentioned with the cafeteria scenario in the workplace, if a person's on TDY and they're staying at a hotel and there happens to be a gym within that hotel and they're working out, there could be a chance that that case might be deemed compensable. Jay and I had to travel here from the Department of Labor facility. If something were to have happened to us en route, we probably would be covered. Because again, it's off premises, but we are engaging in official assigned duties.
But where that's changed for us, where it used to be, the general rule was any travel. Now it is sort of, as Tara kept emphasizing, related to the duties. So if we had gotten in the cab from DOL to here and decided to do a little sightseeing on the way and go via Alexandria and got into an accident in Alexandria, then it would not be covered because there was no reason for us to be in Alexandria where we should have come straight here. So with a lot of things that we do, it gets a little more complicated than the basic thing. But the idea is if they're injured, even though they're not on premises, if it's related to the work they're doing for you, then it'll be covered.
So some other factors to consider in evaluating performance of duty include the list here. You'll see recreation, horseplay, emergencies, union representation, things of that nature. So, you know, if someone's engaging in something that doesn't necessarily seem directly, you know, related to their exact work assignment, but they're, you know, participating in some sort of, drawing a blank here, work activity that was sponsored by the agency where the person was encouraged to attend some sort of
we get like
outside event, training events.
Or if you have a sort of healthy heart program and you encourage people to walk, and perhaps there's a walking path around the building, and people go out and they walk and they trip, even though it's on their lunch hour and they're outside the building. If it's sort of an employee, I think the term is employee-sponsored,
yes,
something to that effect, then it still would be covered.
It's someone here, as it mentions, if they're engaging in union duties, there's, you know, that may be covered. So these are very case-specific. You know, they would be handled on a case-by-case basis, and we would have to look at each specific detail to the case. Moving on here. So there are some statutory exclusions, willful misconduct, drug or alcohol intoxication, or intent to injure self or others. So as it's noted here, there's some stipulations there. Basically, it has to be proven that it's deliberate. If we're talking about willful misconduct, intent to injure self or others, again, sort of it has to be established that the person actively intended to either harm themselves or another person in the act. And drug and alcohol intoxication, again, I don't want to get too in the weeds with that, but as I mentioned, we look at the specifics of each case in evaluating the merits. All right. So moving on here, causal relationship is probably one of the more critical elements that we look at out of the 5. It just involves a little bit more evaluation. And basically what causal relationship is the link between the work-related exposure or injury and any medical condition found. It's strictly driven by the medical evidence provided by the physician. And as it says here, the amount and degree of the causal relationship needed will depend on the type of injury. Certain things are pretty straightforward, and it's fairly easy to make the link between certain orthopedic injuries, for example, but when we start looking at certain occupational diseases that involve a little bit more time to adjudicate, that's where this really gets a hard look. So I'll pass it on to Jay.
Okay, great. And again, before I start up again, I will encourage anyone who has questions to email in. We have our moderators there that are ready, willing, and able to take your calls, donations, or whatever else you're willing to give OPM at benefits@opm.gov, please. Okay, so traumatic injury, Form CA1. So we have clearly, this being the government, we have forms for everything, and we have separate forms for separate things that we do. For traumatic injuries, a traumatic injury is defined as an injury that occurred within a single work day or shift. It tends to be a trip, a fall, an accident of some sort, something that happens suddenly, but it has to happen within a single work shift. For that, they file what's called the Form CA1. The agency must be submitted to the agency within 30 days of the date of injury in order to be eligible for continuation of pay, or COP, which we'll talk about in just a little bit. Not all CA1 forms are submitted from the agency to OWCP. They have to be follow the filing instructions that are on the back of the form. It's very critical that the agency fill them out as accurately as possible. Now, we've done this presentation for a while, so we talk about the form itself, but a lot of it is electronic these days. We have our eComp, which we'll mention towards the end. A lot of the agencies, by regulation, have had to go to an electronic filing format, but it is the same form, basically. It's just not a paper form like it used to be, but the same rules apply. It's all the same data. It needs to be transmitted to us within 10 days from the date the agency received notice. That's the timeliness. And as you see at the bottom of the slide, do not hold in big, bold letters. We've found from our experience that the quicker the claims are filed, whether it be the initial injury claim, the claims for wage loss, anything that the claimant files with you that has to come to us, the faster it gets to us, that's the faster we can take action, that's the faster we get people back to work. Not simply in terms of days, but in the goodwill that it generates with the claimant. If things get held, or if things get lost, or people have to refile, then they start thinking that someone at the agency is not being square with them. And as a result, then they're a little reluctant to return to work when they should return to work, and it makes it more difficult for us to do our job. So where the agencies can really help us the most is to not only make sure that we get the accurate information the first time round, but certainly to file the stuff as quickly as possible with us, because that does help us get the claimant back to work as quickly as possible. So when it comes to the forms, all forms in general, but on the CA1, we ask you to review it for completeness, because you're the one who knows the information that's on the back of it. We have to rely on what you tell us that's on the form. It's self-reported in that sense. We don't have a database that we can go to check to make sure that we've got the correct information. The agency has to tell us. You authorize medical care on the form CA16. For those who aren't aware of it, when there's a traumatic injury, there's a form that you give the claimant, the CA16, that authorizes all medical care, regardless of whether the case is eventually accepted or denied. This allows the bills to be paid without the claimant having to use their health insurance. It takes the doctor's worries out of the way of whether they'll be paid or not, depending on the outcome of the case, and it ensures the claimant gets quick treatment right away. And again, a little goodwill towards the claimant. It's the government's way of saying, let's make sure you get taken care of. We'll sort out the details of whether the case is work-related or not a little bit later, but your injury is first and foremost the important thing here. You also have to advise your employer of the right to elect continuation of pay in traumatic injury claim. And they also advise that their responsibility to submit medical evidence, both to us and then to inform the employing agency, so they know there has been medical evidence, they have seen a doctor, and there is in fact a work-related injury. Did we? Hang on, I think I jumped my thing. I'll just go off the computer. Short form closures. So, of the 120,000 claims we get, that's a lot of claims. And the one way that we deal with these are, we have what's called short form closures. These are traumatic injury claims that are for very, very minor injuries that people tend to maybe see the doctor once, go to the pharmacy, maybe have an x-ray, and then never see anyone again. They're not going to take any leave. This is not a substantial thing. They may have stubbed their toe, and the supervisor said, well, you hurt yourself at work and you need to file your claim. So they file the claim. Short form closures allow the claim to come in and it gets automatically accepted, and it'll pay medical bills up to $1,500, and it allows the agency to pay COP. It will not allow the payment of wage loss. It won't allow for major procedures such as surgery, because clearly that would cost more than $1,500. And it only allows it in certain types of traumatic injuries where it doesn't look like there'll be a third-party involvement, say in a car accident, or something sort of a more serious nature, sort of routine traumatic injury claims, trips and falls, those sorts of things. We've found that we get a good number of these. Of the 120,000 cases we get on average every year, I would say somewhere in the realm of 80 to 85,000 of those are these short form closure cases that come in and just get automatically accepted. People get their bills paid, and then that's mostly the last we hear of it. If the bills go over $1,500, if there is a more serious condition that we're not aware of, then that case calls what we call flips back to an unaccepted claim, and it's adjudicated like a regular claim. So of that 85,000, a certain percentage of those do flip, but a huge majority of them just go all the way through in that nature. There we go. I just got one page ahead of myself. Continuation of pay. This is what I referred to earlier. So this is a big topic. For the benefits officers, it's complicated. We're going to try to hit the big parts of it, but we only have so much time. So if you, again, either email your questions in, or there'll be contact. You can always email them into OPM afterwards, and they will forward them to us, and we'll be happy to answer any questions you guys think of later. While you're laying awake and can't sleep, I'm sure you'll be thinking of continuation of pay. So here are the 5 major topics that we're going to talk about. We'll start with the definition of it. So it's just as it sounds, continuation of pay. You're paying the employee as if they're still working, even though they're injured on the job. When we pay them, we pay according to very different rules, which we'll explain a little bit later. What you're doing is you're continuing their paychecks so that they don't suffer a hardship because of that work-related injury. Again, only in a traumatic injury claim. It basically just guarantees them that uninterrupted pay. It's guaranteed up to 45 calendar days. Those aren't necessarily all in a row. They can be broken up. You get the usual deductions from pay that you would make, allotments for child support, health benefits, life insurance, TSP, all the normal things you do. They're basically just getting their regular paycheck. I believe when you time cards are keyed and whatnot, instead of putting in hours worked, it's COP hours is what happens. Decision to use leave over COP is not irrevocable. They can use their leave and later elect to use COP. It's the employee's choice to do that. It's not something that they're mandated to do. But it is the employee's choice. Again, must be a traumatic injury. They have to file the CA1 within 30 days. They can't file that CA1 a year later and then decide they want COP because they've run out of leave and want to go on vacation. They also must begin losing time from work within the first 45 days of the date of injury in order to be eligible for COP. If too much time has passed, at that point, then they're expected to either use their leave or they'll have to wait until we adjudicate the case and start paying our own wage loss. The employer must continue to pay an employee who is eligible for COP and may not require the employee to use his or own sick leave in almost all circumstances. Now, that's very important because a lot of agencies aren't happy about that. They think that there's no way this claim is going to get accepted, so I'm not going to bother paying it because I'll just have to figure it out later. If it meets those basic requirements of a traumatic injury claim filed within 30 days and not more than 45 days has passed, then COP must be paid. And OWCP has the exclusive authority to decide whether or not entitlement to COP exists. So the agency, well, let's get to the next slide. The agencies controvert COP, which is what we call. So when the claim is filed with us, there's a box that the agency checks saying they're controverting COP, which means they don't agree that they should pay COP. And there's a bunch of reasons that we'll go through as to why they can do that, but it's only these reasons. He's a big faker is not one of those reasons. File that one away. That's not a reason to do anything when it comes to us, although we get that a lot. Occupational disease or illness, that's the biggest one. You know, it should have been an occupational disease. They're trying to file it as a traumatic injury, a CA1, when it should be a CA2 form. CA2 claims are not eligible for COP. The status as an employee, as Tara mentioned, that's one of our 5 basic criteria. They have to be a civilian employee, except in some very limited circumstances where we do have some volunteers and we do have some contractors, war hazard folks that we cover, but that's very, very limited. Otherwise, they have to be civilian employees, and if they don't meet that definition, then they're not covered. They clearly would not be eligible for COP. The employee is neither a citizen or resident of the US or Canada. Not sure why Canada's in there, but somehow Canada snuck in. I'm assuming because parts of the country like Buffalo where people live, work, they couldn't be living in Canada. The injury occurred off the agency's agency's premises, and the employee was not engaged in official off-premises duties. So again, that's a reason to controvert. It's not a reason to not pay. All of these are reasons for you to say, I don't think I should pay OWCP, and then let us make the decision. As mentioned earlier, willful misconduct, intentional harm or death, not on the OWCP approved form within 30 days, work stoppage after 45 days, and, excuse me, reported after the employment was terminated. That also is a popular one. You know, stopped working, now all of a sudden they want to be paid workers' comp. And then some again, these limited, very specific organizations that are mentioned. The reasons for terminating COP, clearly if the person returns to work, there's no need to continue to pay them COP. The period of employment expires. While they're entitled to COP, if they're on, say, a 1-year hire and they're injured 11 and a half months into it, COP would be paid for the last 2 weeks, but it would not be paid beyond the term of their hire. We direct you to stop. That would clearly be another reason. If you controverted it and we rendered a decision and said you are correct, COP stops, or if you paid it for the 45 days. When we direct you to stop or say it's not valid, you can recover COP. You can go back and declare an overpayment and get it back from the employee if it was paid in error. Calculating. So the pay rate for COP purposes is equal to your regular weekly pay, but it excludes certain extras like overtime pay and any other applicable extra pay that the person would earn had they worked it, but is not considered part of regular pay, certainly in our definition. Otherwise, changes to pay which would have occurred during the 45-day period are to be reflected. Promotion, demotion, step increases, all those things. Again, they're basically just getting the paycheck they would have received.
So shifting gears a bit, we're going to now talk about occupational disease, also known as Form CA2. So the difference between a traumatic injury and the occupational disease, as we mentioned before, is that an occupational disease is a condition attributable to exposure to work factors which occurred over a period longer than 1 workday or work shift. As Jay mentioned, we're going to keep reiterating certain points here, but COP is not provided to claimants who file a CA2 claim, and a C16 is not to be issued in conjunction with a CA2 claim as well. A note on timeliness with filing CA2s. They must be submitted to the employing agency within 3 years from when the employee becomes aware or reasonably should have been aware of a possible relationship between the medical condition and the employment or the last day of exposure. So again, there's a little bit more to evaluate in terms of the CA2 claim versus the traumatic injury claims, which, as Jay mentioned, are a little bit more straightforward. The biggest takeaway here probably for everyone in the audience on this slide, however, is not to hold the claim. Just as Jay mentioned with the traumatic injury, if an employee submits the claim, we need to receive it from you within 10 work days of you having received notice at the agency. And again, this is all in an effort to, with the idea that the sooner we get the claim, the sooner we can review it, adjudicate it, make a decision on it, and ultimately get the person back to work, which is one of the main goals of the program. So CA2 adjudication, there's, again, we've touched on this, but because of the complexity of CA2 claims, they sometimes take a little bit longer to review. So the certain timeframes here that are listed is that we try to have occupational disease claims adjudicated within 90 days for simple occupational disease, filings. So again, these are certain orthopedic injuries such as carpal tunnel, just things that you're seeing that are happening over the course of the person's work tenure. But for things that are a little bit more complex, such as stress claims, pulmonary conditions, et cetera, they may take a little bit longer. So there's a window of 180 days for extended occupational disease claims. And just a note on that again, when it comes to things like hearing loss or vision loss, there may just be the fact that there's additional medical examinations that are required to evaluate the person's condition and the merits of the claim. So that's some of the reason for that time period there. So shifting gears again just a little bit, the next few slides we're going to talk about the different types of benefits that are associated with FICA claims. So as you can see here, this is just a table that outlines the death benefits apportionments. So as we mentioned earlier, if a claimed injury or illness results in a death, either at the time of injury or later, survivors or dependents may be entitled to receive certain benefits. And the breakout is listed here. I won't go through each one. But just a note on this, there are certain rules that govern the eligibility status of dependents. So I'll kind of leave that there. Another benefit, obviously, that the FICA provides is medical treatment. So OWCP authorizes medical services, appliances, or supplies likely to cure, give relief, reduce the degree or period of disability, or aid in lessening the amount of monthly compensation. So basically, we need to make sure that the treatment prescribed is in line with the condition diagnosed. And there's certain checks and balances that are in place to make sure that that occurs. And any qualified physician or hospital may provide such services, appliances, and supplies. So getting a little bit more into detail on that Form CA-16 that Jay touched on in discussing the traumatic injury claim. So if your employee files a CA-1 and they indicate that they need medical treatment, the supervisor or injury claimant specialist should be issuing the CA-16 to that individual where possible within 4 hours of the claimed injury. Now, granted, that's not always feasible, but that's the goal that you should shoot for. There are instances in which verbal authorization can be issued, but in that case, the CA-16 then needs to be provided within 48 hours of that verbal authorization. Agencies are not required to issue the CA-16 if more than 1 week has passed from the actual incident. And again, the idea here is that the CA-16 is to be used to obtain immediate medical treatment for traumatic injuries. So if more than 1 week has passed, it's not really considered urgent at that point. There are, of course, other provisions in place, but the CA-16 would not be issued if more than 1 week has elapsed. And as noted again, trying to drill that point home, CA-16s should never be issued, I won't say never, but should not be issued with CA-2 claims for occupational disease.
And just a sort of administrative note on that, don't photocopy them and make them generally available. They are a blank check. If someone presents those to a physician's office and they make a copy of it and send it in with their bill, we will automatically pay that bill, sight unseen, because that's what that form authorizes. So while we encourage the agencies to give them out every time there's an injury, they have to be careful of how they distribute them. So we don't like people to photocopy them. We don't like them to leave them out with all the other general forms. Sometimes, offices will have the CA-1s and CA-2s and those forms generally available for their employees should they need them, which is absolutely appropriate, but this form shouldn't be one of them.
Right, and for that reason, we do not provide that as one of the available forms on our website, nor should any agency.
That's right.
If you do need access to the form, you can generally get it through the agency query system or by contacting your injury comp specialist at your agency. Right. So the next benefit we'll talk about is wage loss. And there's the different components there that we'll go through, but basically, to obtain wage loss, the claimant needs to submit a Form CA-7. The different factors that are looked at and considered are, the computation of the wage loss, certain deductions that are made. The CA-7 form can also be used to repurchase leave, and we'll talk a little bit more about that, I think, in a few slides. And then, obviously, terminating wage loss and knowing when to do that. So Form CA7, as I mentioned, if a claimant wishes to file for wage loss compensation while they're in a leave without pay status due to disability or absence to obtain medical treatment, so, and this is obviously after the 45-day period has elapsed for traumatic injury cases, they would need to submit a Form CA7. Just like generally any other form related to workers' compensation, there's a side A or page 1 for the claimant to fill out, and a supervisor or some sort of employing agency official would complete side 2 in most cases on the CA7. As I mentioned on the previous slide, the CA7 is also used to file for leave repurchase, file for a schedule award claim, or certain lost pay elements for those employees entitled to special pays such as hazard pay, night differential, Sunday differential. And another note here, as we calculate certain pay rates and everything, we're really reliant upon the employing agency for certain data. And hopefully the information that we're receiving from you is accurate first time around, because every agency has different pay bands, not everybody's on the GS scale. There's just so many different variables at play when we're receiving these claims. So we really do rely on the agency to provide accurate data when it comes to pay rates and benefits and
well, and it can't be stressed enough. I'm glad you brought that up, because as everybody knows, in all agencies, improper payments are a big deal. And for us, we get dinged with the improper payment if we pay exactly the way the form says, but that was wrong. And so, again, we're relying on what the agency is telling us. So if the stuff on the back of the form, giving their pay rate or their health benefits or life insurance is the incorrect code, and it turns out to later be wrong, well, that's an improper payment on us that we have to recover. Now, the agency ultimately suffers as well because we're using their funds to pay the claimant. So if we've overpaid someone, we've overpaid with agency funds that we have to recover. But the improper payment piece is also a big deal for us. It's one of the more common reasons we see for improper payments is that the information we're getting from the employing agencies is not, it's not that it's not accurate, it's that when we do see improper payments, frequently it's because of inaccurate information on the back of these forms. So I can't stress enough to try to be very careful and very accurate when you're filling these out.
Okay. So moving along to CA7 adjudication. Just as with the injury and illness forms, there are certain timeliness standards associated with submitting the CA7. So if an agency receives a CA7 form from an injured worker, they are obligated to turn that around and submit it within 5 work days of receipt of that form from the employee. OWCP then has, if we, upon receipt, 14 days to take some sort of action after receiving that form from the employing agency. So again, the biggest takeaway is to remember there's certain timeliness standards, and 5 work days are what apply to the CA7 form. So if a CA7 is approved, the pay rates need to be computed. And those are either based on, the pay rate that we pay claimants is either based on the pay rate they held at the date of injury, the date that the disability began, or the date of recurrence, provided that that recurrence happened at least 6 months after a return to regular full-time duty. And we go by whichever is greater out of those 3. A few additional notes on computation. We calculate a weekly pay rate for payment of compensation based on the information that we receive from the agency. So again, as Jay stressed, we're really reliant on what we receive from you in terms of those different types of hourly wages, weekly wages, annual wages, because every agency virtually has pretty much a different pay type, right, and different special pays offered to employees depending on the position. For payment of death benefits, a monthly pay rate is calculated. So as you can see, based on this list, there are several elements that are included in that pay rate once that's determined. I won't go through the full list here, but most of these include those premium pays that I referenced earlier. Again, it pretty much depends on the position type that the person held when they were injured. In contrast, there are also elements that are excluded from pay. And since this list is a little bit shorter, I can go into it. As with COP, overtime pay is not included. Locality or COLA pay for employees outside the US is not included. There's no bonus or premium pay for extraordinary service, per diems. As you can see, the list continues. And then I
Yeah, the
think-
basic idea is, we keep stressing, is that people are not harmed by being injured at work, and they're getting the pay that they should be getting. So that leads us right to our next slide in terms of how we calculate it. So because the one interesting part about what we do is our benefits are completely tax-free. So we do not deduct tax. Not only do we not deduct taxes, but clearly our claimants don't pay income taxes. So that's always a big deal around tax time. We get lots of calls about, why haven't I gotten a 1099 or a W-2 or something from you so I can pay my taxes? And we don't do any of that. So instead, we have different rates of pay that we calculate for people to try to approximate what they would be having deducted from their paycheck, so that their take-home pay is close to what they would be getting had they be working. So our pay rates, the basic pay rate is currently is 66 2/3%, or basically 2/3 of their full pay, or 75% if they have at least one eligible dependent. Again, if you think about that in terms of a tax-free benefit, there's no deductions for FICA, there's no deductions for state tax, local tax, federal tax, any of those sorts of things. When you roll all that stuff in, it probably approximates it relatively closely. Also, for period of entitlement, we have what's called waiting days. If the claimant is disabled for 14 days or less after the end of COP, but when they file the first claim with us, the first 3 calendar days of disability are not paid. It's a slightly different example for the Postal Service, but that's all other federal agencies are the same. So what it basically amounts to is if there's a very little bit of disability after the COP period ends, the claimant's not compensated for it. We'll go through the next few screens. Are going to just talk about all the various things we do make deductions for. The FHB is clearly a big one. We actually deduct premiums from the first period day that the person's on wage loss. It used to be a waiting period. There is no longer. We also pay the agency share of the premiums. The agencies do not. We pay that. The claimant doesn't pay it either, though they're sometimes confused and they think that they are. If disability lasts more than 90 days, we transfer in, or is expected to last more than 90 days, we transfer in the enrollment. We become the payroll office of record. This, for those of you that deal with health benefits, they deal a real gray area here, because people go back and forth sometimes. They're disabled for a little while, they go back to work, their injury gets worse, or they go out for a surgery, so then they're off again, then they go back to work part-time. There's a lot of back and forth with ours. It's not, say, just going from working to retirement, where you have to do all those conversions and calculations, but then they've pretty much gone there and then you're finished. For ours, folks are going back and forth. So especially in health benefits and life insurance, it makes it difficult to kind of keep track of. But our general rule of thumb is, in 90 days of ongoing disability, we'll transfer in so that we can report to CLEAR, so that they know that we're the payroll office of record and people maintain their health benefits. We, not the employing agency, are responsible for open season changes if the person is on our rolls and we're paying. This happens every year. A person makes an open season change. They go online to Employee Express or whatever they've got at their employing agency. They make an open season change, which gets processed. Well, that's great, but no one ever tells us, so we continue to deduct their old health plan, which they're no longer enrolled in. They're enrolled in a new plan, but no one tells us that as well. And only after a while does someone realize they have no entitlement. And they probably get a nasty gram from either the old carrier or the new carrier about not getting paid. So it creates a lot of confusion as well. We are the payroll office of record at that point. We're the ones that take over all that responsibility. The best way to look at it is you don't have to do it anymore. Just pass to us. The last piece is just a little unique. It's what's called the postal rate. Postal employees have different rates for FEHB depending on which postal union they belong to. What it really amounts to is the Postal Service pays a little bit more of the agency share, so the employee pays a little bit less of this total cost. And so as a result, during the first year before they're generally separated, we honor that rate, and the Postal Service makes up the difference between the two. After a year point, and it's based on the pay rate effective date, the date of injury. After that year point, then they're considered all like all other federal employees, and they're charged the regular FEHB rate. Some other deductions that we make: we do take FEGLI, we do dental vision, as well as spousal and child support. We work very closely with BeneFeds on dental vision. They match up our claimants to anyone in government who's reported leave without pay to ensure that they immediately get moved over to our rolls. They'll make the deductions for us. If a period has lapsed between when we started paying the person and when the employer last covered, they'll literally double up the deductions to make up that back period so that the person eventually is current and they maintain their coverage. We only do dental and vision for those that are on our what we call our periodic rolls, which is our monthly benefit, as opposed to those that are getting paid intermittently. If they're only being paid intermittently from us, either a couple hours a day or a few days here and there, then if it's not consistent, then benefits will bill them directly, or they'll deal with the employing agency in order to get the deductions taken out. Certain things we don't take out. Long-term care. When OPM went live with long-term care, we did all this work to try to get ready for it, and then they had the open season, and we had exactly 4 people enroll in it out of all the people that we had on our rolls. So it ended up being too much work for too few people. I'm not sure why that played out that way. My guess is our claimants figured that between FEHB and us, they're taken care of, so they don't need long-term care. We do not do flexible spending accounts. We don't do thrift savings either, and as we mentioned before, taxes. Leave buyback. So, the employee can always use their sick or annual leave as opposed to filing a claim with us when they're in that leave without pay status for workers' compensation. And if they choose to, then they can come to us and file a claim to buy back that leave. It's calculated that we would have paid for that period. There's probably a small amount the employee owes the agency because the agency would have taken out other things like the taxes. And then they have to make up that difference. But once that's done, the leave is restored. What's interesting about leave buyback is it's at the agency's discretion. The agency is one of the few times where the agency can absolutely deny the claimant the benefit that we would normally honor purely at their own discretion. So sometimes we get these requests for a very long and very old period of time. I've literally seen 20-year-old leave buyback requests when someone's getting ready to retire and they may need maybe a couple more months of service time, and they'll remember that workers' comp injury they had way back when that they used their leave for and didn't file a claim for wage loss, and they want to buy back the leave so they can tack that leave on. Those kinds of things, the agencies have the absolute right to say, no, we do not want to allow you to buy back the leave, and that's their right. Cost of living adjustments. Injured employees are entitled to cost of living adjustments for after 1 year of being on disability. That year, March 1st is our line in the sand, so the claimant has to have been on our rolls for a year as of March 1st. So the preceding calendar year, I think is the term it uses. Entitled to compensation as well. It may not necessarily be total disability, but entitled to compensation for at least 1 year before March 1st. The way we do it is a little bit differently than others. We're similar to Social Security, but we do it differently. We base it on December to December, the cost of living increase as published by the Bureau of Labor Statistics within the Department of Labor. They keep a cost index for that, and we measure by Decembers. So in December of 14, you have a set cost index. Come December of 15, we'll look and see what that cost index is. Whatever it's increased, that would be what the cost of living increase that we would grant the following March. For the first time ever, a couple of years ago, we had none. That's never actually ever happened. Federal employees had no increases for a couple of years, but I don't think that had anything to do with the COLA. Termination of wage loss. Once we accept the claim, we now have the burden of justifying termination of compensation benefits. So when we start putting someone on our monthly rolls, we can't say, oh, okay, we're not getting the proper evidence from the doctor. We don't think you're disabled anymore. Prove it. We have to actually submit the proof that the person's no longer disabled. The burden falls to us. The right to medical benefits is not necessarily affected when this happens. So frequently, we terminate wage loss because a person either has gone back to work or has the ability to go back to work full time. Even though they're working, though, they may still need to occasionally see the doctor or go to physical therapy or need some sort of supply or medication for their injury, and we would continue to pay that even if the person is working full time. However, entitlement to FEHB and life insurance, at least via us, stops when wage loss stops. We only extend that coverage if we're actually paying wage loss. Other reasons for termination: a fraud conviction, refusal or abandonment of suitable employment. Now, this happens frequently, and this happens with OPM frequently, actually. We put someone through voc rehab, and we get them very close to their maybe in job placement, and it's getting close to the point where we're saying, you know, you can go back to work now. We found a job for you, and they decide, well, I really don't want to do that. I'm going to go retire. I'm going to OPM. And so they go to OPM. Well, at that point, we will issue a decision saying you refuse suitable employment and you've lost all entitlement to wage loss. They can come back later and file a claim, and it would have to be adjudicated. But for that particular claim, based on those incidents, we would stop all wage loss. We used to have an issue with people going back and forth between OPM and OWCP because that election is not irrevocable. They can go back and forth and back and forth. And so that was one way to not have to take suitable employment. They could go retire for a bit and then go back onto workers' comp. Clearly, no continuing work-related disability is a reason to stop paying folks. Or if we find that they've had zero loss of wage earning capacity, either what we call actual or constructed. So at the end of voc rehab, if we've done through all the training and we found what's a suitable, we think is a suitable job, if they actually return to work, we'll do a wage earning capacity decision based on the earnings that they'll make over 60 days. If they're making just as much money as they made when they were injured, well, then clearly we don't need to pay any wage loss. But often they don't make as much, and we'll pay a small amount or whatever is necessary to get them to the point they were in when they were injured. We sometimes do that as a constructed. When the person does not return to work and does not cooperate, we have to sort of construct what the wages would be for that type of employment that they were trained for or qualified for had they returned to work and worked a full-time job. Schedule award. Sorry, I went a little too soon. Schedule award is an award that we pay to the claimants that is different than disability. What we've been talking about now, up to now, is disability, where people cannot return to work. A schedule award is an award that's provided for specific periods of time for permanent loss of use of certain body parts. There'll be a chart in just a moment, or I'll explain it to you. But it's a permanent impairment of that part. So if someone was to lose a finger in an industrial accident, they would get a schedule award for the loss of use of that, 100% loss of use of that finger. You could have a knee injury and your doctor, after the proper examination is done, determine that you have a 7% loss of use of your left knee. It's just never going to quite be the same again. You would get an award for that too. The law doesn't allow for payment of a schedule award for impairment to the back, heart, or brain is something to note. But in terms of a back injury, if it does lead to impairment of something else, like a leg. Frequently, a very severe back injury could lead to loss of use of a leg, if not total loss of use. Certainly give someone, say, a limp, or it makes it very difficult for them to walk, then the impairment would be to the leg as a result of the back injury. This chart is a chart that we use. The numbers that you see represent weeks of compensation. So, and this is all for 100% loss of use. So for example, if you lost an eye, you poked your eye out, we would pay 160 weeks of compensation to the person based on whatever the weekly salary is that we determine for compensation purposes. It should also be noted that this can be paid at the same time that they're working or if they're getting OPM retirement benefits. And obviously there's a bunch of things in here. The skin was recently added. That was a relatively new one done after 9/11 because of a lot of the horrible injuries that went on at the Pentagon and in New York City. So the Congress added that as a scheduled member. And that leads us into dual benefits. So a schedule award can be paid while other benefits are paid, such as OPM retirement benefits. But a lot of other benefits are not. OPM is clearly the big one. Death benefits, the lump sum benefit. We can't pay disability for the inability to work and pay someone retirement at the same time. We're not going to pay a widow death benefits and have OPM pay death benefits at the same time. So certain things there are prohibited dual benefits. The Social Security Act one is a little interesting. We would offset dollar for dollar any retirement monies that Social Security pays for FERS retirement related to federal service. Gets that down into the weeds. If a person has some civilian employment, we don't offset for that, but for the federal portion of it, we do. Social Security offsets for any monies we pay for SSDI, for their disability insurance program, because again, you wouldn't be paying Social Security disability and workers' comp disability at the same time. Elections between OWCP and OPM, as I mentioned earlier, they are not irrevocable. People can go back and forth. However, we do tend to pay more than OPM does in retirement because ours is based on a salary, it's based on wages, and wages tend to be higher than retirement benefits. So we tend to be a little bit more of a popular choice. However, we have a lot more stipulations and requirements ongoing to claimants, so it makes us a little less popular at times. You know, they have to be totally disabled. They have to not be able to work whatsoever. We make every effort, as Tara said, it's our goal to return people to work. We're going to try to return them to work. And if people don't want to return to work, they're probably much happier retiring with OPM.
Thank you for stealing my segue. So return to work, obviously, next slide. We're going to talk a little bit about employers' responsibilities. Before we get too into detail, we'll cover a little bit about OPM restoration rights, just so everybody's clear on when people can come back and what they can come back to. So if a person recovers within a year and they're a permanent employee, they have the right to be restored to the job they held when injured or an equivalent position. Such an employee is expected to apply for reemployment with his or her agency immediately upon recovery. So again, the big picture here is, return to work is obviously the biggest goal of the program, and everyone involved in claims should understand that, including the claimant. So that's why the onus is on them to apply for that reemployment as soon as they're recovered. Separately, if an employee takes longer than a year to recover, the agency actually has the right to separate that individual. But that claimant does remain entitled to priority consideration, provided that he or she applies for that reemployment within 30 days after the compensation ends. So again, there's provisions in place, there's routes to take, but that's basically restoration rights wrapped up there. So if something important to remember in terms of return to work, and we'll get into job offers in a few moments, but if there's an alternative position available for a partially disabled employee, so if somebody can come back instead of working a full 8-hour shift, if we can bring them back to work for 4 hours, if we can modify their duties in some way to at least have them working some sort of light duty job, we certainly advocate for that and expect you to partner with us in making that happen. Where there are no alternative positions available, however, you would advise the employee of any accommodations that the agency can make. So, again, the big picture here is that, we want to return people to work. And I don't know if someone from OPM wants to make a plug, but in terms of separating employee after that 1 year is up, it is important that they apply for their retirement, OPM retirement. And that's just, to provide them with some sort of cushion in the event that their workers' comp benefits were to be terminated or end at some point. So, I don't know if you had anything else to add to that.
No, go ahead.
Okay, so.
Oh, hang on.
Oh. I don't know if you're on. I don't hear you.
Nope. Just a moment, we have a question or a statement.
Do you want to try one
in the
of
back?
them? And while we're waiting, if anyone has questions, we encourage you to submit those to benefits@opm.gov. Okay, sorry about that. Important thing, as we mentioned, it is important that employees are informed that they should be applying for their OPM retirement after that, at that 1 year point, if they are separated. Okay, so return to work, acceptable reasons for refusal. So if it's determined that a light duty type of job is available to an injured worker, there's certain rules and stipulations that go along with drafting a light duty job offer, but if an employee is presented with a suitable job offer, there are certain acceptable reasons for refusing that job offer. Obviously, if the job offer is made and then subsequently withdrawn, there's nothing for them to accept. If the claimant found other work which fairly and reasonable represents his or her earning capacity, they would be allowed to refuse that job offer. If the medical evidence establishes that the condition has worsened and the claimant is unable to perform duties. So again, one important note here is that any job offer that's drafted should be adherent to whatever medical restrictions the treating physician outlines. So if a job offer is drafted and issued to that person, and in between that time there's some sort of medical evidence that comes in from the physician saying, initially we thought this person could lift 20 pounds, but now they can only lift 10, that person could refuse on that basis. If the attending physician advises the employee not to accept, again, they can refuse the job, but OWCP will further develop that part of the claim. If the claimant is unable to travel to the job because of the injury, and if another medical condition has arisen since the compensable injury and prevents the claimant from working, that would also be an acceptable reason for the claimant to refuse the job offer. In contrast, there are also unacceptable reasons for refusing a job offer. They simply can't say no to the job offer because they don't like the area in which the job is being offered. So if if the person decided to haul off and move to Florida and it's not related to something pertaining to the work injury, they can't just turn the job down for that reason. They also can't turn the job down simply because they do not like the type of work hours offered. They also can't say no based on lack of promotion potential, lack of job security, retirement, or their age. So, I don't know. Were you ready to make your comment there? Just a quick pause. I think the mics are working again.
I was just going to add that it is OPM's recommendation that somebody who goes out on workers' compensation for an extended period of time over that year apply for their SERS or FERS retirement, because there are no survivor benefits under workers' compensation. So with the FICA benefits, while it can be higher for the employee to get the 66 and 2/3% or 75%, you're not offering any survivor protection. So when somebody retires, they can suspend their retirement benefit, and then if they would die, they have survivor protection. That's a really important point for retirees. The other thing is under SERS, you want to meet the 1 out of 2 year rule, which has to be done with retirement deductions. And if you're not and pay from an agency, you're not paying retirement deductions, so you wouldn't meet the 1 out of 2 year rule requirement under SERS. So it really is important for benefits officers to counsel employees correctly and tell them to apply for benefits and then suspend.
Right. And the first point is a good one, because we do get that a lot, where people, excuse me, assume that the injured worker assumes that if he's on the rolls, he or she is on the rolls for a long period of time, that if they should die, that their spouse would be covered. That's only true if the death is work-related. So if the person has a horrible back condition which prevents them from ever working again, and they're on our rolls for a very long time, but then die eventually, say, of cancer, we're not going to pay any more benefits. Our benefits are literally going to stop on the spot. And had they not done something, as Karen mentioned, or had they not paid into, had enough service time for anything, sometimes that leaves dependents in a horrible position. So as benefit officers, really does help do a real service to people. Although they probably think you're just trying to get them back to work, it does do them a really great service to inform them of the things that could happen if they stay on the rolls long periods of time and don't have other alternatives. Do we have a question? No? Okay.
And just sort of in that same vein, it's maybe a good point to note too that these are two separate programs that we're talking about, and oftentimes we may see claimants feel that they are in a retired status if they're on long-term disability through workers' comp, and workers' comp is not a retirement program. So, okay, so back to, we talked about return to work. We'll talk about vocational rehabilitation a bit. So voc rehab it's not generally the first course of action. It's sort of the last stop. After we've gone through the cycle of looking for a job with the employing agency, some claimants are eligible to participate in the vocational rehabilitation plan. And in that, it may involve medical rehabilitation, work hardening, placement with a previous employer, although again, as I mentioned, by this time, usually the outcome following voc rehab, if a job is found for that employee, it's often in the private sector with a new employer. But part of what voc rehab provides is oftentimes training for injured workers. They'll look at skill sets and look at matching those with different jobs in the local area for that person. And there's actually a voc rehab specialist that works closely with the claimant in the hopes of employing them at some point. Again, most of the time, though, the outcome is that they're employed with a private sector employer. Okay. So we're going to talk a little bit about loss of wage earning capacity. Jay touched on this a little bit in his previous slides, but loss of wage earning capacity, or LWEC, as it's also known as, is provided by the FICA, and it's basically, I'm not going to read word for word from the slide here, but as Jay referenced, there's something in place through the FICA that if a person returns to a job that did not pay as much as their date of injury job paid, we work to make that person's salary whole. So it's based on a calculation. We're not going to go too far into it because this is just a basic overview here. But like the slide says here, if the disability is partial, OWCP will pay 66 2/3% or 75% of the difference between the current pay for the job held when injured and the current pay for the job which represents the claimant's capacity to earn wages. So again, if there's a gap in that salary, we'll work to process a calculation that essentially makes up for the difference of what that person would have made had they not been injured.
Right. So if a long period has passed, the person was a GS11 clerk, we wouldn't look at their GS11 salary from the time they were injured. We'd look at the GS11 clerk salary, what it paid today. And then we'd look at what they had the actually ability to earn actually working and pay the difference between the two. It's a little more complicated than that, but at a very basic level, that's what it is.
Yes. Okay. And moving on, we'll talk a little bit about appeal rights. So it's important to note here, this applies to any adverse decision made on a claim. So it's not just the overall acceptance or denial of the claim. It can be denial of a request for treatment. It could be denial of a wage loss claim. So in the event that a denial decision is issued, the claimant has 3 routes of appeal, and those are either to file for a hearing, a reconsideration, or to file an appeal with the Employees Compensation Appeals Board, also known as ECAB. So, and this is always outlined to the claimant in writing when that decision is issued, and it's their choice to elect which appeal route best suits their situation. So with a little bit about a hearing, it can either be an oral hearing or a review of the written record. And there's different time requirements for these different routes of appeals. Reconsideration would involve generally a senior claims examiner reviewing the case, someone who has not previously reviewed the case and been part of that decision. And then the ECAB is essentially like our Supreme Court, if you will. There's actually 3 judges that are on the panel of reviewing the merits of the claim. And the interesting thing with ECAB is that their case law can actually be set as a result of decisions issued from the ECAB. So again, I won't get too far in the weeds with this because this is just basic, but just note that there are provisions in place or recourse for the employees to take if they are not satisfied with the decision issued on their case. So we're coming to a close here. Just want to make sure, again, as we keep saying, this is just a basic overview of OWCP. If you need more information or are looking for more information, please bookmark our homepage. It's listed there on the site. And I also want to make a plug for a new automated listserv that we've recently opened up to federal agencies. We also have separate listservs for providers and attorneys, but I encourage all of you to register for the listserv. Link is there, and you'll find it on our webpage. This will, going forward, be the main route of you receiving communication and updates from us. We previously managed this through a distribution list, but because of turnover on agency side of injury comp specialists, it's just a lot easier for you guys to be able to go in and register so that you're making sure you're kept apprised of the ongoings within our program. So we'll send out, notices will be distributed through the listserv for things like interagency meetings or just, general news that may apply to you. And just another note here, in terms of our webpage, you'll find previous trainings listed on the website, just different FAQ type things on our website. But we do have other tools available to agencies. AQS, it also knows, the Agency Query System, also known as AQS, is a tool that most agencies use. It's pretty straightforward. It gives you a variety of information about the claim, including most notably the case status. This is sort of a snapshot of what one would see upon logging into AQS to review a particular case. So, you can see the accepted conditions. It also allows you to go into, I'm going to show a slide here, all the different listed compensation payments that were issued and their various status. You can actually click on those links to see a worksheet that breaks down the different deductions that are made on those individual payments. And there's the worksheet I just referenced.
Yep. There's a bunch of things about, let me interrupt for just a second. On AQS that is great for the benefit officers. So you can, when you get calls from the claimants, you can go into AQS very quickly and easily and see the status of either the claim that's filed or if it's actually been paid. But the piece that we like you to do is to look at those initial payments when you have a new claim to see that we did pay it correctly. We may have gotten something on the form that we thought was a code for health benefits or life insurance or the salary that was completely wrong. It may have been the way the form was filled out. It may have just been the way we read it. So we kind of ask the agencies to look at the initial payments, especially if they have access to AQS, because you can look and say, well, okay, that's correct. That's what we put on the form. That's what so-and-so's pay was. It helps more for your perspective when you get those calls from the claimants wanting to know information, especially about payments. Payments is the big one, and AQS has got everything they could possibly want to know, from the pay rate to all the what was deducted. It'll even tell them if the child support and things like that were deducted from it. Right. So if you don't have access to it, please contact. You probably have an agency coordinator. Each agency has a coordinator that sets up user IDs and passwords for AQS. You don't even have to come to us. Find out your agency coordinator. If you don't, you can contact us and we can put you in touch with that person in your agency.
Right. The other thing AQS provides is a link to bill pay. So again, if you're getting questions from claimants about bills that have not been paid, the link to the bill pay site is also provided through AQS. And likewise, there's what's called the claimant query system that you can inform claimants about. They can essentially see what we see here in AQS and answer questions on their own about their status of their wage loss claims and bills being paid. So now I will go over briefly eComp. eComp was rolled out a few years ago in the spirit of moving agencies towards electronically filing claims. There was actually a mandate that went out in the CFR about electronic filing. So eComp, we keep referring to it, it's actually the Employees Compensation Operations and Management Portal. And just an overview, eComp, it's a web-based application accessible via DOL through an MOU, in which allows injured federal workers and their employers to electronically file things like OSHA 301s, CA1s, 2s, 7s, and CA6 claims, death claims. Through eComp, though it's not a case management system, you can track the status of forms submitted through the system. Essentially it gets things to us quicker, which we've been saying all along, allows us to review and adjudicate claims and authorize treatment where necessary, and ultimately in the hopes of getting that person back to work. So,
well, and by regulation, all federal agencies have to file claims electronically now.
Right.
So this is a free option that we offer to the agencies that they can sign up for and file claims electronically with us. Some of the agencies have legacy systems where they've been filing electronically with us for years, so they don't use eComp, they use whatever they've had. But this is available to all those, any other agency. Right.
So again, it's web-based. This is the basic homepage of eComp, if you will. Again, its purpose is to allow for uploading documents to the file, and virtually anyone can do this. Providers can submit medical documentation to a case file. Claimants can submit things to their case file, and claimants, upon suffering a workplace injury, can actually go into eComp to initiate a claim, which is then routed to their supervisor and eventually onto us for review. So as I mentioned, being able to upload documents is something that eComp offers through WEEDS, which is a component of eComp. It stands for Web-Enabled Electronic Document Submission. Again, pretty much anybody who has certain pieces of information, such as the claim number, the date of injury, the claimant's last name, and their date of birth, can in turn submit documents electronically directly to the case file. So that saves the trouble of dropping something in the mail. The basic eComp filing process, as I mentioned, an employee or their contractor can file a 301, which transcribes certain information to a CA1 or CA2 if that feature is turned on. And then the employee can file either their CA1 or CA2 claim, whichever applies, or even a CA7 to claim the wage loss benefits and other benefits that we discussed. An agency reviewer or OSHA reviewer can also initiate forms on behalf of the injured worker, and certain agencies are set up to manage their claims that way. Another feature of eComp that several employing agencies enjoy is what's called Agency Reviewer Imaging, or ARI. This allows claimants, employing agency specialists with access to this feature. There's a certain amount of licenses that are distributed, and you would have to contact our office to get set up with that. But basically, this allows you to sort of do a case review and look at certain documents within the case file. It's important to note that all of the rules that govern the management and maintenance of case files apply here, even though it's electronic. Privacy Act, DOL Gov 1, routine use, all apply here. So you can't, you just go sifting around inside the case file. There has to be an approved use for doing that. That ties back to the case management. And generally, it's for return to work purposes and, just overall case management. But, it's a nice feature because you have access to what's there and, can probably do a lot more on the agency side than previously prior to eComp's inception. So, and this just shows there are certain rules about what can and cannot be uploaded to the case file via eComp. And just certain guidelines as far as the formatting and the number of pages that can be submitted, but that's sort of it in a nutshell. And I guess we didn't get questions throughout, so.
I was going to say, we finished
Right.
quite early just
Yeah.
because we usually get a lot of questions and everyone's quiet today, so. I want to thank you very much for your time.
Or do we have questions?
Oh,
Okay.
you were supposed to interrupt us as we went along. Okay, that's why we went so fast. Okay, well, bring it on.
Okay, you have to kind of set your head back to 113 when this question was taken. If an employee is exercising after hours during TDY, is it covered?
Okay, so let me start these. Every single one of these types of questions it's on a case-by-case basis. It really does depend. But as Tara had mentioned before, sort of normally expected activities will be covered. So you would expect something that if you're going to authorize exercise during the day, then you probably would authorize exercise after work. So I would say maybe, but it depends on the circumstances. It really does.
Right. And I think you mentioned the scenario being on TDY.
Yeah.
Generally, employees are covered 24/7 on TDY if they're performing duties reasonably.
Right.
You know.
So that wouldn't be a material deviation. In other words, it wouldn't be unreasonable for a person to be exercising while on TDY. So the odds are good that they would be covered.
Right.
Okay, next question. Is the injured employee required to complete a paper, handwritten OWCP Form CA1 or CA2, or can the injured employee substitute this action with the agency's internal computer electronic submission system to the DOL?
So right now, we do require that a wet signature is maintained on a claim form. So, you know, while employees may be initiating claims through an electronic system, there should be some way of capturing that person's signature on the printed out version of what's been entered into the system. So we do need a signature right now.
Okay. I'll take the next one. I work for an agency that has hospitals and clinics. It seems that these facilities have not enrolled in ACS. Is there someone at ACS who can help someone at each clinic or hospital complete the enrollment?
Yes. So ACS has a provider enrollment department. That's exactly what they do. They do outreach constantly. So all they have to do is actually contact ACS, and they can get the number from our webpage to contact ACS. And someone at ACS would gladly work with, they could work with, at the agency level if necessary, but the individual facilities could contact them as well.
Can you address telework injury?
I was waiting for that. Telework always comes up. Telework it's always an interesting discussion. So again, the basic premise of telework is someone's working. It doesn't really matter that they're working at home or they're working in your office. They're still at work. Most telework agreements, I think if not all, has the employees stipulate that they work in a proper work environment that's safe. In other words, they're not balancing on a stepladder while they're typing on a laptop that might fall over on them. So as long as they're following all the mandates of that, if they happen to walk into the kitchen to get a glass of water and they fall and get hurt, then yes, it would be covered, just like they would if they fell if they were walking to the bathroom in the office. At the end of the day, telework is no different than regular employment. It makes people nervous because they're at home versus being in the office, and clearly they're not going to have witnesses or coworkers around and things like that. But the basic premise is the same. It's work.
When a short form is flipped to a UN status, does the $1,500 coverage end?
I sense a ringer. Usually it flips to UD, and usually it flips because it's gone over the 1,500. So what that means is that we started paying bills and it's reached that $1,500 threshold. At that point, if it's UD, it's not an accepted claim anymore, so nothing else is paid until we adjudicate that claim.
An employee had an injury many years ago when he worked at a different agency, but has no records. He now believes the injury is causing him problems again. How can he obtain those records?
So it sounds like this scenario involves a claim for recurrence, which we did not get into too deeply here at all. But I would think the proper route to advise that person to take is to go ahead and file the claim for recurrence. And I mean, I don't know how old we're talking this claim is, but it's possible that there's some sort of archived record on our end that we could possibly refer to aid in the adjudication of that recurrence.
Yeah, and it's really not the burden of the claimant to get records from the employing agency as a rule. If we want information regarding the original claim, then we would ask if they have some things. But generally, we would try to get that from the agency, or as Tara said, go through our own archived records.
Right. Since we are officially the keeper of the files of the official records, so I would think that at some point we would be able to access that.
Okay. If an employee is TDY attending a course, injures themselves, receives medical care, stays out of the class the next day, and travels, the morning they did not attend the class is COP, correct? Even though it is a travel day?
Yes.
Yes.
Yes. Doesn't matter if it's a travel day or not. At
Well,
least not
and-
for OWCP purposes.
Yeah, I mean, and again, there's certain rules that govern COP. We would need to have that medical documentation saying that they were disabled that following day, but yeah, those rules apply. But in a generally speaking, yes. that
Correct.
could
If it
be
was just a
COP
regular
day.
travel day anyway, they would be paid as an employee because they would be on travel regardless. If they didn't, in the part of the example where it said they didn't attend class,
Right.
then that would be a COP day because they couldn't go to work, i.e. attend class.
At my facility, we frequently receive notes describing employees as completely disabled, even for a paper cut. Is this a problem countrywide?
That's a pretty severe paper cut. Again, we do see that in all kinds of conditions. That is the heart of our job. So we look at those things, and if we get medical evidence from a physician that says someone has a paper cut and they're totally disabled, unless they're working in a lemon juice factory, which that would be pretty awful with a paper cut, we would have to either go back to the physician and ask questions to explain why they're totally disabled, or send them out to a second opinion, which would be another physician to say, this person has a paper cut, are they totally disabled? If that second opinion came back and said, no, they're absolutely not totally disabled, but the treating physician still insisted they were, we'd have to send them to a third exam, an impartial medical exam, an IME. That person sort of acts as the authority in the case and decides between the two physicians which one has the weight of the medical evidence, and then we would go by that decision. But we develop the medical is the short answer to that. We'd have to keep pursuing it. Just because they say they're totally disabled does not necessarily make them totally disabled.
If an employee submits a claim and there's discrepancy in the information, should the agency get it resolved first and submit the e-comp or submit the e-comp within the 10 days and try to get it resolved afterwards?
I would probably need to know exactly what that discrepancy refers to. I mean, yeah, that's a little challenging. I mean, if it's a discrepancy with the home address or something like that, there's certain things that can be administratively corrected fairly easily. If we're talking about a discrepancy in terms of there being a disagreement about the nature and cause of injury, I don't know that that's something that could or should be resolved at that point. I would
Right.
say in that case, go ahead and submit the claim and let us handle the development part of it. But if it's something technical like an occupation code, for example, I wouldn't get hung up on that and have that be a reason for delaying the claim.
In general, we want the things submitted as quickly as possible, so it could always be submitted with a note explaining that they're trying to work out another discrepancy in the claim, but here's what they have to date.
Right. But accurate information up front is always appreciated.
Yes.
Can you define physician? Does it need to be MD, or can it be a nurse practitioner or physician assistant?
What do we recognize? these
So, yes. So there are certain rules that apply. We see this question come up a lot with chiropractic
Right.
care, and there's certain conditions or factors of a condition that need to exist in order for a chiropractor to be recognized. I'd have to refer back exactly to the rule because I know it has changed, but a qualified physician generally is going to be an MD or PhD. If a physician's assistant has signed off on some sort of medical, I believe the regs still say that that needs to be countersigned by an actual MD or PhD.
So the MD, the physician's assistant can see the claimant, but the MD would have to actually sign off on it. We tend to just recognize MDs, but we do allow them to be examined by others as long as the MD signs off and then, yes, this is proper.
Right. Same goes for physical therapists. They're not recognized as, they can provide updates as to the person's condition, as to their progress through the physical therapy sessions, but they're not, able to provide that.
No diagnosis
unquote,
or anything
yes.
like that.
In rural Alaska, our nearest health clinic has a physician assistant. He can usually address most injuries. Are there provisions for rural areas where the CA-16 can be accepted with a PA signature when the nearest medical doctor is over 2 hours away?
I think we cover, bearing in mind we cover federal employees around the world. So you have rural Alaska, I'm sure, has its challenges, as do people have challenges in Afghanistan and Russia and all kinds of parts of the world. So I think it's a sort of, as a general rule, we want it signed off on an MD, but I think if the agency worked with the local workers' compensation office and explained the issues, that they would come up with a solution with that, to work with them to make sure they got the proper signatures.
A question about leave buyback. How long does the employee have to use the leave they buy back? For example, if they are in over their 240 hours, will they lose it at the end of the leave year?
So I don't know that that's come up. I don't know that I've seen that where a leave repurchase would result in putting them over the 240 amount. I almost want to say that's probably at the discretion of the agency, of the
Yeah.
employing agency.
I'm not positive, but my thought is that the regular rules still apply. So if someone buys back a lot of leave, they'd have to use that leave. I don't think it's automatically carried over because I
Yeah.
don't think it has any special categorization. It just turns into annual or sick leave.
Right.
Now, it depends on what kind of leave it was. If it's sick leave, then there's no provision for the year. If it's annual leave that they use and annual leave was restored, I still think the 240 applies. But I think Tara's right as well. They could probably work with if the agency saw that in December someone got 400 hours of annual leave restored, I don't think they're going to turn around and take it all the way in January.
Right. And during the estimation process, if the person finds out that it's going to put them over, they may decide, well, if I'm going to lose it anyway, I don't want to buy it back. So.
Correct.
Just trying to rephrase this in my head. This is on, they have an employee that has law enforcement availability pay. When they initiate the CA-7, is there a specific coding that you want them to use other than the other category?
So
For the type of pay?
So when a CA-7 is submitted and we're looking at determining that pay rate, we will go back to the agency and ask whether or not that person earned any special pays. And any calculations for those allowable special pays would be gathered at that point. I don't know that the actual code is so much as important as the actual amount of the pay that's been accumulated by that person. So,
Correct.
And
So-
if it's something that's intermittent, that doesn't, it's not just a standard type of special pay that they always receive, we would then go back and ask for 1 year prior payments of that type of pay category, whatever those special pays were, and look sort of at an average of what they earned for that period of time.
Yeah, and we deal with a lot. I mean, imagine every single pay system that's out there we have to deal with. So if we were to create a form that accounted for every code and every type, it would be dozens of pages. So that's why a lot falls under other. As long as it's clear what it's for and the amount, then other will work just fine.
Okay. What is the notification process to let agencies know to transfer the FEHB to DOL?
So this comes up every time as well. There is no such thing as a transfer out of health benefits. If no one believes me, Mr. Health Benefits himself is in the audience giggling as I say this. The agency has no requirement to transfer it out to OWCP. We always appreciate it when they send us copies of things and a cover letter saying we deducted as of this date and here's the code. But the actual concept of transfer out doesn't exist anymore. We simply transfer in. When we transfer in, we become the payroll office of record. When we stop paying compensation, the employing agency then transfers, if they return to work, transfers in, and then they become the payroll office of record. So there's no sort of notification or date or notice. We tend to do it, and a lot of times the district offices will send a copy of the 2810, I would guess, to the employing agency so they know that we've done it. But we simply take the health benefits enrollment. That's basically how it works.
This is kind of a two-parter. When an employee has advanced leave for OWCP and has repaid it, is he eligible for the buyback of that leave? Does the advanced leave count as the employee's leave?
The short answer is leave buyback is at the discretion of the agency. So if it gets too complicated, you can just not allow them leave buyback. That said, that also comes up every time. If you've gone to a leave bank and it got donated to you, it's a leave donation. It doesn't go back to the leave bank. It's up to the agency whether they want to allow someone to buy that back and keep it, but frequently, in my experience, the agencies do not allow them to buy that back. They use it, and that's it.
Right.
It's simply bought back. That's, the use of it is what it was intended for, and that's all.
Right, and that's generally annual leave or sick leave only in those categories.
Right.
Okay, and this was tied to the same question. When the employee's leave is restored via OWCP leave buyback, and the total's beyond the 240 at the end of the payroll year, is he exempt from losing the hours above the 240?
Right, that's what we were talking about
Yeah.
earlier. But really, I don't know the exact answer to that. I don't think so. It may vary from agency to agency. They should probably just have their injury comp person check with the benefits to be sure. I would imagine that it's the same rules, but I think timing would play into that.
Okay. This is a specific question. If the OWCP goal is to return a claimant to work, then why do I have a claimant that has been on disability since 2013, and there's been no effort to evaluate the claimant for the possibility of returning to work? The claimant is relatively young and only has arthritis in the right ankle. The claimant could be retrained for a desk job.
Well, okay, we can't answer case-specific questions. I'm sorry, because I haven't looked at the case file, so I don't know what else is going on in the case. I will tell you that they manage the case files, and the way our law is written, while we don't call it whole person, there are other factors that are involved. So again, I'm not saying it's related to this case. So if it's the person's right ankle and they have to drive to work and they cannot use their right ankle to drive to work, well, then it's very difficult to get to work, and we probably don't expect them to walk. So that may be the reason. It's impossible to know. We can't do case-by-case specific. Now, what I will say, though, and make a plug for, is that the injury comp specialists in the agencies can write to us and ask us that very question and say, why haven't you returned this person to work? Relatively young, just an ankle injury, and we are more than willing to give them a desk job, because we will probably jump at the fact that you will offer them a modified position.
Yeah. Similarly, agency comp specialists are permitted to write to the treating physician if they have questions about what they're seeing in terms of medical evidence, but that is limited to written correspondence. They can't call on the phone. And
Correct. Can't call, nor can they show up and harass
Exactly.
a doctor about a claimant, because we had issues with that, and we actually had to make a rule about it. But they can write to the physician and say, are there additional medical restrictions, so that they can take all of that into account and make a job offer.
In the second part to that, how does the agency submit a request for investigation of potential fraud on the part of a doctor providing medical evidence of a claimant's disability?
You've got two avenues there. One, I think your best bet would be your own OIG. OIGs these days are very interested in medical fraud, and that's not, ours is clearly because of what we do, but I found that in all of the agencies, because there's so much going on across government now. The Justice Department is constantly going after individual providers, drug companies, they're getting big settlements. In the IG community, that's a very popular thing. What we encourage them to do is contact their own OIG. If they don't have the resources or the wherewithal to do it, then they can contact our IG directly through the IG community, and they certainly will pursue it. Okay.
How often do you handle health and wellness or PFP claims, and do you have any helpful hints for the agencies on that?
I'm not
sure.
sure.
I'm not familiar with that.
Yes.
So I'm sorry, I can't provide a good answer for that.
Okay, last question.
Yeah. And
How long after a death will OWCP pay compensation? Does the agency have to complete any forms for a deceased employee on IWC rolls?
So there's the CA6, well, if they're already on our,
Yeah.
if they're on our rolls at the time, we'll probably contact the widow directly. So there probably isn't a form for them to fill out. If the employee dies in the line of duty, then they fill out the CA6 form. In terms of time on the rolls, it's mostly for the life of the widow. So it depends on the family
Or
situation.
widower.
I'm sorry?
Or widower.
Widower, pardon me, pardon me. Widow or
Survivor.
widower, but unless they remarry before age 55. If they remarry prior to age 55, they receive a 2-year lump sum settlement, and then that's the end, that we don't pay any further. If they don't remarry, then we would continue to pay. If the dependents are only, for example, children, let's say, then it would be until they reach age 22, and then their entitlement would stop.
I think we're going to go for about 10 more minutes, if that's okay. We have about 12 questions that are unanswered, so
Okay.
we'll
Okay.
continue.
Sure.
Sure.
Oh, we just need you to wait
Wait
for a
1 second.
microphone so everyone else can hear.
Yeah, because they can't hear it otherwise. Thank you.
So this is follow-up to the question about the death. So dependents, and if there are any surviving dependents, how would we know that as the agency if they've been on your rolls since 1989?
Fair enough. Well, you don't probably, but I'm not sure that you need to. We would know that. I mean, we would pay them. You'd probably have some case documentation. If you have access to AQS like we talked about, you'd be able to see it there. Again, you can always contact us and ask. In terms of just straight dependents, the spouse, see, you got around widow and widower and said spouse. The spouse would be entitled probably for the rest of their life, most likely. The children just to that age of majority. So you could check that. You also get, the agencies get their chargeback reports, which is each individual claim, you get exactly what we spent. So when you know that Mr. Smith has passed, and then yet you see on the chargeback that we're still paying, I'm sure you would look and you'd see, well, wait a minute, we're paying less, but we're still paying. That would be a clue that we're paying a death claim, and you'd probably be able to figure it out from there.
We have an employee who's been separated from our agency and is still paying medical expenses for the, and our agency is still paying the medical expenses for the employee via chargeback. How can we go about getting the status update on the employee's condition?
So, okay, so the employee is on workers' comp rolls or somehow, maybe not working for that agency, but we're paying for their medical. So essentially, even if a person moves on to another agency or stops working,
Right.
That agency owns, the bills associated with that claim. In terms of wanting to get a medical update, again, if the treating physician is known, as we mentioned earlier, that employing agency can certainly write to the treating physician. If they have access to something like ARI through eComp, they can, view documents related to the medical reports there. And they could certainly partner with the claims examiner at the district office where the claim is being managed out of to ask, for updated medical. I mean, again, they're assuming, the responsibility for the bill at the end of the day, so they would certainly have a right to request that information.
Okay. We have an emergency room that refuses to fill out the doctor's portion of the CA16 or CA17. How should this be handled?
That's a good question. And that's always a problem for claimants. Ultimately, as long as the bills are being paid, I mean, that's the important part. The claimant can always write to us and write to the agency and explain that they have that dilemma, and we'll work our way around it. We're not going to hold the claimant responsible because a facility is not cooperating. We have issues with that across the bill pay world where they don't want to deal with our bill pay contractor, for example. And so they don't do X, Y, and Z, and it puts the claimants in a difficult position. So we're flexible about that. The best thing to do would be for the claimant to contact us.
But in terms of gathering medical evidence to support a claim,
Right.
that the claimant does have the burden of working their best to get that. I mean,
Correct.
they have the right to the choice of initial physician. If at some point they find they need to change physicians, maybe if things like that are becoming too burdensome, they are able to write to the claims examiner to request a change in physician. So.
And I mean, it's an emergency room, so I'm assuming it's first visit.
Right.
When the person's first hurt. And so we're probably asking for some evidence that the injury occurred or what happened, et cetera, and they're having a hard time getting that, so they're having a hard time proving their claim. So at that point, they're probably better going to either their regular physician to get an evaluation or to find a workers' comp physician to give them an evaluation and use that for the medical evidence on their claim.
How do agency personnel who process OWCP claims request access to the agency reviewer imaging system?
They, again, if an MOU would need to be signed in order to get set up with eComp, and then, you know, from there, we would work with you through my branch, actually, to get you set up and getting a license for ARI. So.
When our office is required to respond to a DOL notice from a hearing, can we upload that response as opposed to mailing it back?
I believe so,
Everything-
yeah.
yeah.
As long as it falls within the guidelines of what can and can't be uploaded, and, you know, page limits and things like that are taken into consideration, I believe so, yes.
Can a claimant on a limited lightweight duty assignment work more than just Monday through Friday and claim CA 7A hours for part-time, right? And claim CA 7A hours for part-time for those premium hours?
Well, I guess it depends on the job that they've set up. If someone is in a light duty position, they generally set up with the employing agency what their hours are, what the job is. If it's flexible and they have the right to work premium pay hours, such as weekends, then they're entitled to.
But it would need to fall in line with whatever the issued work restrictions are.
That's what I
So,
mean, yes.
yeah,
It has to be set up within whatever the light duty job was,
Yeah.
how that was set up. If they're leaving it to the employee's discretion, and at their discretion, they're choosing to just work the premium pay hours, then I don't see a big problem with that. But if they're claiming they can only work so many hours a week, and yet they manage to put in overtime, then that's a different issue.
This is a question in regards to the FICA Circular 0904, published in 2012, states
Ooh,
that
my favorite.
states that FEHB deductions become effective on the first day of leave without pay status. Is this correct?
That is correct.
Is there an update? Yeah, is there a way to update the claimant's information other than resubmitting the Form CA-7? Can we upload a typed letter into eComp instead of filing another CA-7?
Sure. Because you don't want to file a CA-7 if there's not an actual claim, some kind of claim. CA-7 is not meant to update information.
Yeah, right.
Unless they're claiming more compensation. The CA-7 is simply to claim compensation. So if they're trying to claim more comp, then that's what you do. If you want to say, whoops, I got the pay rate wrong, or I gave you the wrong HB code, or his address on the CA-7 form was wrong, then a letter is absolutely appropriate there. You wouldn't file another CA-7.
Correct.
Right? Okay, so we did have questions after all. Well, thank those in the audience for attending. Thank those online for attending. We do appreciate your time. And if there are more follow-up questions later, then please contact our benefit officer friends here at OPM, and they will pass them to us, and we will respond as quickly as we can. Thank you very much.
Thank you.